The judge read through the case like he was checking off a grocery list, and my brother stood up before the final syllable left the judge's mouth. Not because he was eager to honor our grandfather, because he was eager to claim him. He wore a Taylor Navy suit, the kind of understated power that makes people assume you're right before you even speak. His hair was perfect. His face was dry. And when he looked at me, there wasn't grief in his eyes. There was calculation. His attorney, crisp suit, smooth voice, expensive watch, walked up to the clerk's table with a thin stack of papers and slid them forward like a blade. "Your Honor," he said, "we're moving for immediate transfer of the estate to my client, effective today." My parents nodded in unison behind him, like they'd rehearsed this in front of a mirror. My mother's hands were folded solemnly, as if she were in church, and my father stared straight ahead, jaw locked like this was a board meeting and I was the obstacle. The judge didn't look at them at first. He looked at me. "Mr. Carson," he said, voice flat, "do you object?" My brother's lips twitched like he could barely wait to hear me beg. I didn't beg. I straightened my spine, placed my hands on the table, and made sure my voice didn't shake. "Yes," I said, "I object." His attorney smiled, a thin, condescending smile. "On what grounds?" he asked, already confident he'd steamroll right over me. "I haven't given you the grounds yet." "Not yet. I want to wait until the last person arrives," I said. The judge blinked once. "The last person?" he repeated. I nodded. "Yes, Your Honor." My brother let out a laugh that wasn't humor. "This is ridiculous," he said. "There's no one else." My father finally turned his head slightly toward me, the way he used to when I was a teenager, and he wanted to remind me I was embarrassing the family. "You always do this," he muttered, voice low enough that the judge leaned back and adjusted his glasses. "Mr. Carson," he said, "this is probate court, not theater. If you have an objection, it needs to be legal." "It is legal," I said calmly, "but it's not mine to explain." My brother's attorney stepped closer, voice calm. "Your Honor," he said, "we're requesting an emergency consultation because Mr. Carson isn't cooperating. There are assets that need protection, and my client is the responsible party." Responsible. That word had always been weaponized in my family. It meant give us control and stop asking questions. My mother sighed softly, as if she was suffering through my immaturity. "He's grieving," she told the judge, "and doesn't understand how these things work." My brother's eyes stayed fixed on me, clear and cold. "I'm just trying to keep everything from falling apart," he said. "Grandfather would want this handled the right way." I stared at him and thought about how quickly he'd found an attorney, how fast the petition had appeared, and how rehearsed my parents looked sitting behind him like backup singers. The judge turned a page in the file. "This petition requests full authority over the estate," he said. "It alleges the respondent is unfit to participate and may interfere." My brother's attorney nodded. "Correct. And you're asking me to grant this today?" the judge asked. "Yes, Your Honor," the attorney replied. "With immediate effect?" The judge looked at me again. "Mr. Carson," he said, "what is your objection?" I kept my posture still. "My objection is that they're asking you to act without the complete record," I said. My brother laughed again, sharper this time. "There is no record," he snapped. "He's dead. That's what happens." The judge's expression didn't change, but his patience thinned. "Mr. Daniels," he said to my brother, "you will not speak without permission." My father's lips pressed tighter. My mother's eyes narrowed, as if she hated being corrected. My brother's attorney tried to salvage the moment. "Your Honor, if Mr. Carson wishes to delay, we object. The estate cannot wait." I didn't look at him. I looked at the judge. "It won't be a delay," I said. "It'll be minutes." The judge sighed once and glanced toward the courtroom doors, clearly deciding whether to humor me. "Who are we waiting for?" he asked. I answered with the simplest truth I could speak aloud. "The person who actually controls the inheritance," I said. For the first time, my brother's face twitched. "That's me," he said automatically. Then he caught himself when the judge's gaze shifted to him. The judge leaned slightly forward. "Mr. Carson," he said to me, "if this is a tactic, it's not," I replied. "I'm asking you to let the record arrive before you sign anything." A beat of silence. Then the courtroom doors opened. It wasn't a dramatic swing, just a clean, controlled push like someone with purpose. A woman walked in wearing a black suit so simple it looked like a uniform. No flashy jewelry, no briefcase, just an envelope in her hand and a calm expression. She looked like she didn't care who had money in this room. She walked straight to the clerk's desk without glancing at my parents or my brother. She held up the envelope, spoke clearly, and said, "For the court from the trustee." The judge blinked, took his glasses off again, and looked at the envelope like it didn't belong in his courtroom. The woman in the black suit didn't raise her voice. She didn't explain herself. She simply placed the envelope on the clerk's table with one hand and said, "This is for the court from the trust administrator." The judge picked up the envelope, read the return address line, and his mouth moved like he was speaking before he should. "This can't be," he whispered. The judge didn't open the envelope like it was ordinary mail. He held it between two fingers, turned it once, and looked at the return address again, like the ink might change if he stared hard enough. Then he tore it open, not with a flourish, a clean tear, like he wanted the paper to stop pretending it mattered more than what was inside. The courtroom went so quiet I could hear my brother's attorney shift his weight. The judge pulled out a single folded document first. Heavy paper with an embossed seal in the corner and a signature block that looked too formal for the way my family had been treating this, like a family meeting. He scanned the first line. His jaw tightened. Then he read the return address aloud. Sterling Trust Company, Fiduciary Department. My brother's face flickered for a half second before he regained composure. He'd built his entire adult life on being the person who handled money. Hearing a trust company's name spoken in open court should have made him look powerful. Instead, it made him look cornered. The judge kept reading. "This is a notice of trust administration," he said. "The document indicates that the grantor's assets were placed in a revocable trust and that the trust became irrevocable upon death." My brother's attorney stood quickly. "Your Honor, we're in probate. This is—" The judge didn't even look up. "Sit down," he said. He turned a page. "And this," he added, voice flattening, "is a trust certification identifying the administrator." He paused again, like the next sentence had offended his sense of how court proceedings were supposed to work. Then he read it. "Successor trustee, Sterling Trust Company, Fiduciary Department." My parents tensed because they'd been aiming for control. A trust company doesn't care about control the way families do. A trust company cares about documents, conditions, and risk. My brother's attorney tried to recover the case with confidence. "Your Honor, even if there's a trust, probate court still has jurisdiction over the estate." The judge finally looked up. "Counsel," he said, "your motion requested that the entire estate be transferred immediately." He tapped the paper lightly with one finger. "This trust certification states in plain language that the probate estate is minimal and the bulk of assets are in trust." He turned to the clerk. "Mark this as received," he said. Then he looked at my brother, not as a brother, not as family, but as a petitioner who tried to take something he didn't control. "Mr. Daniels," he told my brother, "did you know your grandfather established a trust with a corporate administrator?" My brother lifted his chin. "He was influenced," he said. He didn't understand what he was signing. The judge didn't challenge his feelings. He held up the next page. "Well, this notice includes a copy of the trust execution affidavit and witness list," he said. "It also includes an attorney certification that the grantor signed in full capacity." My father's mouth twitched. My mother's eyes narrowed, like she was trying to find a new angle. And then the judge reached the sentence that made him whisper, "This can't be right." He read slowly, so no one could later claim they'd misunderstood. "No contest clause triggered. Any beneficiary who petitions to seize trust assets contrary to the trust terms will forfeit their distribution." My brother's attorney's face went pale. My brother's eyes widened slightly, then narrowed, as if he was trying to intimidate the paper into yielding. My mother's hands came apart for the first time. The judge looked up. "Counsel," he said to my brother's attorney, "you filed a motion for immediate transfer of the entire estate to your client." "Yes, Your Honor," the attorney said carefully. "Do you understand," the judge replied, "that if this clause is enforceable, the very act of filing your motion may have already caused forfeiture?" The attorney swallowed. "Your Honor, we contest the validity." The judge cut him off. "You can contest," he said, but you can't pretend it doesn't exist. Then he looked at me again. Mr. Carson, he said, you asked to wait for the last person to arrive. Was this the person? Yes, I said. My voice stayed calm, even though my pulse had climbed into my throat. The trust department is the trustee. They control distribution. The woman in the black suit, still standing near the clerk like she belonged to a procedure, spoke for the first time. Your Honor, she said, calm and precise. I'm not here to argue. I'm here to notify and confirm the trustee's position. The judge gestured once. Go ahead, he said. The woman didn't look at my parents. She didn't look at my brother. She looked at the judge. The administrator does not recognize the petitioner's claim, she said. Based on today's motion, the trustee will not distribute assets to anyone. Estate administration will follow trust terms, and we request the court deny any attempt to seize assets controlled by the trust through probate. My brother bristled. You can't just... The judge raised his hand. Mr. Daniels, he said sharply, you will not speak out of turn. My brother closed his mouth, but his breathing changed. Faster now. Shallower. His attorney stood again, trying to regain ground. Your Honor, at minimum, we're requesting full production of the trust instrument, he said. We question whether my client was improperly removed or whether there was undue influence by the respondent. The judges looked and softened. Undue influence is a serious allegation, he said. And you've just reviewed audio evidence of a coercion attempt directed at the grantor that didn't come from the respondent. My father's jaw clenched. The judge turned back to the woman in black. Has the trustee provided the trust instrument to counsel? He asked. Yes, the woman replied. A complete copy was delivered yesterday to both sides by certified service. My mother's head turned sharply toward my brother's attorney like a whip. Yesterday, which meant they knew, or should have known, which meant they filed anyway. The judge let that fact hang in the air for a beat. Then he looked at my brother with something close to disgust. Mr. Daniels, he said, did you receive the trust documents yesterday? My brother's lips parted, and for the first time, he looked less like an executive and more like someone cornered. He started. His attorney interrupted quickly. Your Honor, we received a package, but the judge cut him off. Counsel, he said, if you received a package containing a no-contest clause and still filed an action demanding the entire estate immediately, I want you to understand what that looks like in this court. The attorney went still. The judge turned to the clerk. I want a hearing scheduled on validity and sanctions, he said, and I want the trustee's letter entered into the record. Then he looked directly at my brother. And Mr. Daniels, he added, voice colder now, if you're a named beneficiary and you triggered the penalty today, it may have cost you more than you intended. My brother's face twisted into something ugly. His eyes turned to me, and the hatred there wasn't about money. It was that the institution he thought would crown him had labeled him a risk. So he did what he always did when he couldn't win with paperwork. He tried to win with a new story. Your Honor, he said suddenly, voice loud, turning to the bench with practiced urgency. I need to put something on the record. The judge's eyes narrowed. What? He said flatly. My brother looked directly at me and spoke the one word my parents had been holding like a bullet. Elder abuse. And the judge's expression changed, not because he believed it, but because now the court had to decide if he had evidence or if he was about to hang himself with another false allegation. Elder abuse, my brother repeated. A louder tone could turn the accusation into proof. My mother's face softened instantly into a practiced look of sorrow. My father leaned back in his chair, eyes half closed, like this was the plan they'd been waiting to execute. His attorney stood beside him as if he'd been offered an emergency exit. Your Honor, he said, we're requesting an immediate investigation. The respondent isolated the grantor, controlled access, and coerced him into signing documents that benefited him. The judge didn't react like a daytime TV audience. He reacted like a judge. He leaned forward and said, Counsel, these are serious allegations. What evidence do you have today? My brother didn't blink. Witnesses, he said, and gestured backward. Two relatives stood awkwardly near the back rows, like they'd been drafted last minute. An aunt and a cousin I barely spoke to. Their faces were tense, their eyes avoiding mine. My mother nodded at them encouragingly, like she was coaching them silently. The judge looked at them, unimpressed. "Witnesses can testify," he said, "but I want something concrete. Medical reports, prior complaints, police reports, APS involvement. Anything." My brother's jaw tightened. He didn't want to embarrass the family, he said quickly. He was afraid. The judge's expression remained flat. "Then explain why he called emergency services himself," he said. Silence. My brother tried to pivot. He was confused, he said. He didn't know what he was doing. The judge looked at the envelope again. "Well, this trust was executed with a capacity declaration and witnesses," he said. "That's not confusion. That's formalized intent." My father's attorney stood, voice measured. "Your Honor, we also have evidence that the respondent had access to accounts and controlled communications." My attorney, Mitchell, stood immediately. "Objection," he said. "This is argument without foundation." The judge raised his hand. "Counsel," he said to my brother's attorney, "do you have this evidence here?" My brother's attorney hesitated for a fraction. Then he did what attorneys do when they have a narrative but not the record. "We'll be seeking discovery," he said. The judge's look hardened. "Discovery isn't a license to fish," he replied. "You don't accuse someone of elder abuse in open court as a strategy to seize assets held in trust." My brother's face flushed red. "It's not a strategy," he shot back. The judge leaned back. "Then present the evidence," he said. "Not theater relatives." My mother's voice trembled. "Rehearsed." "Your Honor," she said. "He pushed us away. He made him hate us." The judge looked at her once. "Ma'am," he said, "this isn't family therapy." Then he returned his attention to the one person in the room who had no emotional investment, just fiduciary responsibility. He addressed the woman in black. "Ma'am," he said, "does the administrator have any documentation of concerns regarding undue influence or abuse?" The woman didn't hesitate. "No, Your Honor," she said. The administrator conducted standard intake protocol. The grantor met privately with counsel. He confirmed his intent. The administrator received a letter of instruction and supporting materials. The judge's gaze became sharper. "Supporting materials?" he asked. "Yes," the woman replied. "A recording and a written statement." The grantor wanted them preserved. My brother's head snapped up. "What statement?" he demanded. The judge didn't look at him. "Provide it," he told the woman. The woman reached into a second envelope she'd been holding, one I hadn't noticed because it was thinner and unmarked, and handed it to the clerk. The clerk passed it to the judge. The judge opened it and removed a single-page letter. He read it silently for several seconds, his eyes moving with careful attention. Then he looked at me, not with tenderness but with the weight of something he understood. "Mr. Carson," he said, "did you know your grandfather prepared a written statement anticipating today's accusations?" "Yes," I replied quietly. "He told me he did, but I didn't know what he wrote." My brother's breathing changed. His nails dug into the counsel table. The judge looked at the top of the letter. Then he read the first line aloud. "If you're reading this in court, it means my son and his family attempted to take my estate by accusing my grandson." My mother made a sound like she'd been stabbed. My father's face went rigid. My brother's attorney sat slowly, like he'd realized he was standing on a trapdoor. The judge continued reading, not all of it, enough to make the record undeniable. He read that my grandfather had asked me to live with him after his fall. He read that he'd met with his attorney privately. He read that he'd created the trust because he feared pressure tactics and rush signing demands. Then the judge reached the line that seemed to make his lips compress. He read it once silently, then aloud. "On the night I called emergency services, my son brought a mobile notary to my house to obtain new signatures. I refused. I asked for witnesses. If they call this elder abuse, they're projecting their own behavior." The courtroom remained in complete silence. Not a whisper, not a cough. My brother went very still, and I watched his eyes blink like he was trying to find a way to survive the record. My father's attorney stood slowly, voice cautious. "Your Honor," he said, "we object to hearsay." The judge cut him off. "It's a statement of intent from the grantor and offered to show his state of mind," he said. "And it's consistent with the dispatch audio." He lifted the letter slightly. This court will not entertain an 11th-hour elder abuse claim to seize assets under corporate trust administration, he said, pronouncing each word with precision. If you want to file a petition with evidence, you may, but not today. Not like this. My brother's attorney swallowed. Your Honor, he said, we'd like to withdraw the motion. The judge's look stayed cold. You can't reverse consequences, he replied. But you can stop digging. He turned to the clerk. Motion denied, he said, and schedule a hearing for sanctions briefing regarding the filing and the false allegations made today. My mother's face went pale. My father's jaw clenched. My brother's mask finally fell. He lost it. So he gets everything, he said. His voice cracked. The judge didn't hesitate. The trust will be administered according to terms, he said. And yes, Mr. Daniels' petition to seize the entire estate with immediate effect is denied. My brother's hand shook. He tried to disguise it by gripping the edge of the table as the woman in black spoke again, calm as a machine, laying out the next step. The administrator will suspend any distributions to parties who triggered the no contest clause pending further review, she said. We will strictly follow trust terms. My brother turned his head sharply toward her. Stop, he hissed. She didn't argue. She simply said, understood. The judge leaned forward and said the last sentence my brother hadn't expected to hear. Mr. Daniels, he said, you walked into this court acting like it was already yours. Now you'll leave with no ruling in your favor today, and you'll answer for how you try to get it. My brother's eyes turned to me again, full of hate and humiliation. Then he whispered, almost inaudible, this isn't over. And that's when the bailiff approached, quietly, unprofessionally, and spoke to the judge in a low tone. The judge's expression shifted slightly as he listened. He nodded once. Then he looked directly at my father. Mr. Carson, he said, remain seated. My father froze. Why? He asked. The judge's voice stayed flat. Because, he said, I've just been informed there's a process server in the hallway with papers for you, and they're not from this court. My father's face twitched. The courtroom doors opened again, and a uniformed officer walked in holding a document with bold lettering across the top. I couldn't read the caption from my seat, but I saw my father's face pale when the officer said, Sir, you've been served. My father didn't stand, didn't demand respect, just stared at the officer like the badge had suddenly become heavier than his money. What is this? He asked, voice tight. The officer wasn't playing games. He held out the packet. Subpoena, he said. You can accept it here or in the hallway. My father's attorney leaned toward him and whispered something urgent. My father ignored him and snatched the papers from the officer's hand, flipping the first page with shaking fingers. His eyes scanned the header. Then he froze because this wasn't a probate filing. It was criminal investigation paperwork. The judge watched him read with an impassive expression. Mr. Carson, the judge said, this court has nothing to do with that paperwork, but I will remind you that you're still under oath from earlier testimony. My father swallowed. Your Honor, he said, forcing calm. This is harassment. My family is being targeted because of my son, the judge interrupted. Stop, he said. Your son didn't call emergency services to report a coercion attempt. Your son didn't file a false lawsuit. Your son didn't try to take trust assets administered by a corporate trustee. My mother's mouth tightened. We were trying to protect the family, she whispered. The judge wasn't moved. Then you protected him right into litigation, he said. The officer shifted slightly, and I noticed he hadn't come alone. 2 more uniformed officers stood near the doors, silent, not approaching, just present the way police present when they expect people to run or explode. My brother's attorney cleared his throat. Your Honor, he said cautiously, we request a brief recess to confer with our clients. The judge looked at him like he was exhausted at the thought of more talking. You can confer, he said, but this motion is denied. The trustee will administer the estate, and I'll call counsel back for the sanctions hearing. He picked up his pen, already moving away from them. Then he stopped and looked back once, like he'd remembered something important. One more thing, he said. The room stopped again. He addressed the woman in black. Ma'am, he said, is the administrator requesting any protective orders? Yes, Your Honor, the woman replied immediately. Given the attempted interference, the administrator requests an order prohibiting petitioners from contacting financial institutions, custodians, or third parties attempting to access trust assets, and prohibiting harassment of the primary beneficiary. My brother's head snapped up. Harassment, he scoffed. The judge's eyes turned to him. Mr. Daniels, he said, you just accused someone of elder abuse without evidence presented in open court. You're not in a position to scoff. He looked back at the trust representative. Granted, he said. Draft it. I'll sign today. My mother's face went pale. You can't stop us from seeing our own son, she whispered, voice shaking. The judge's voice stayed flat. You can refrain from committing any misconduct, he replied. Mitchell leaned toward me and murmured, This is the cleanest order we could have hoped for. I nodded once, but my eyes stayed on my parents because now my father had criminal papers in hand, and I could see the calculation shifting in his look. Not remorse. Damage control. The judge adjourned. Court is in recess, he said. The instant the gavel hit, my mother lunged toward me in the aisle. Not physically, but close enough that the air changed. You did this, she hissed. You ruined your father. I didn't hesitate. He ruined himself, I said quietly. My brother interrupted, his voice a tense whisper, eyes wild. You're going to lose everything, he said. I'll make sure you do. I looked at him and kept my voice calm. You already tried, I said, and the administrator didn't even have to raise her voice. My brother's face contorted. You think you're safe because a trust company filed paperwork? He spat the words. I leaned slightly closer, close enough for him to hear me over the hallway noise. I think I'm safe because grandfather planned everything, I said, and because you can't intimidate a record. His lips parted, and I saw the moment when he wanted to scream. Instead, he did something colder. He turned his phone face down, like he'd just sent a message he didn't want anyone to see. Mitchell noticed too. His gaze flicked to my brother's hands, then to me. Let's go, he murmured. Let's get out. We left through the side exit. The air outside the courthouse was cold and sharp, like it didn't care what families did to each other inside. On the sidewalk, Mitchell stopped and looked me in the eye. Here's the concrete ending you wanted, he said quietly. The trust is in control. The petition was denied. The no contest clause was triggered and will be enforced. Your parents won't have access, and the court just issued an order blocking interference. I nodded. And my brother? I asked. Mitchell's mouth tightened. If he's a named beneficiary, he probably forfeited today, he said. That's what his attorney is realizing right now. We stood there for a moment, just breathing. Then Mitchell's phone buzzed, and he checked it, and his expression changed the way it had at the airport when the officer's tone shifted. What? I asked. Mitchell held up the screen. An official notification. Short. Sterling Trust Company. Security alert. Access attempt blocked. My stomach went cold because the hearing was over. The protective order was signed, and someone was still trying to get at the money. Mitchell's voice went low. They're doing it right now, he said. I stared at the alert, and in that moment I understood. My brother hadn't turned his phone face down to keep from screaming. He turned it because he was making a move. Mitchell didn't waste a second. He called the trust department while we were still standing on the sidewalk. The courthouse doors were behind us, and my parents somewhere inside, trying to pretend they hadn't just been humiliated. A woman answered with a firm, "RehearseCom, you hear from people whose job is preventing disasters." "Sterling Trust," she said. "This line is recorded. How may I help you?" "This is Mitchell Lane," he replied. "Counsel for David Carson. I just received a security alert. Blocked access attempt. I need details." There was a brief pause and the sound of keys being typed. Then the woman's tone became slightly sharper. "Confirming protocol," she said. "Yes." A login attempt was made on the beneficiary portal. Multi-factor authentication failed. Immediately after, there was an attempt to change the registered contact phone number. My mouth went dry. "Change it to whose?" I asked. The trust officer didn't answer me directly. She asked Mitchell, "Do you authorize me to release attempt request data to your client?" "Yes," Mitchell said immediately. The trust officer continued. The phone number change attempt was submitted from a device associated with petitioner Marcus Daniels. I closed my eyes for half a second because I could picture it perfectly. Him turning his phone face down in the courthouse like he was hiding shame, when really he was hiding an action. Mitchell's voice stayed calm. "Did he authenticate?" he asked. "No," the trust officer replied. The system blocked the request. A manual flag was placed. "Distribution status is now set to hold, pending fraud review." Mitchell let out a slow breath. "Good," he said. "Freeze all changes. No contact alterations on the portal. No phone number, email, or address changes unless there's in-person verified ID." "Already done," she replied, and a report was generated. Mitchell's jaw tightened. "Send that to my office," he said, "and note that there's a protective order issued today prohibiting interference." "Understood," she replied. "We have the protective order filed. The administrator will comply." The call ended, and the silence fell alert. Mitchell looked at me. "That attempt," he said, "is exactly why corporate trustees exist. They don't get intimidated. They don't get manipulated by guilt. They just log and block." I nodded slowly. "So he tried to get in," I said, "and failed?" "Yes," he replied. "And he just created a record that will follow him to sanctions." We went straight to Mitchell's office, not for drama, but to make sure everything was locked down. While my family was still reeling, Mitchell had me sign a single page of instructions. All trust communications to be routed through counsel, no direct family contact accepted, and any change attempts to be treated as fraud. Then he forwarded the bank's security report to the judge's clerk with a note. "Blocked access, attempt minutes after court recess." No threats, no speeches. Just a timestamp. An hour later, Mitchell's assistant came in and said, "The trust representative returned the call." The woman in the black suit, Sterling's representative, appeared on a video call. Same composed demeanor, same understated suit like a uniform. "Mr. Carson," she said, "I want to make something very clear." I didn't speak. I let her do it. "The trust will distribute amounts only according to trust terms," she continued. "There will be no exceptions due to family pressure. No temporary transfers. No advances." She glanced at a note, then back up. "And due to today's petition and the portal interference attempt, the administrator has formally determined that Marcus Daniels triggered the no contest clause. His distribution is now suspended pending court confirmation." My chest tightened. Part relief, part disbelief. Mitchell asked, "And the parents?" The representative's expression didn't change. "Grant and Linda Carson's contingent distribution is under review," she stated. "Given their participation in the petition and coordinated behavior, the administrator is treating their involvement as interference." She paused and added, "We'll be filing a declaration with the court." That was the moment I felt it was over, not because it was emotionally satisfying, because it was administratively final. 2 weeks later, the court held the sanctions hearing. My brother's attorney didn't make eye contact with anyone. He stood, cleared his throat, and said, "Your Honor, we withdraw all contested allegations and apologize to the court." The judge didn't smile. He didn't accept the apology like it erased the attempt. He imposed sanctions for bad faith filing and ordered my brother to pay a portion of attorney fees, and most importantly, issued an order acknowledging the trustee's enforcement of the no contest clause. Then he addressed my parents directly. "Your son didn't take anything," he said. "Your father's documents took control from you, and you responded with manipulation. This court won't participate in that." My mother cried in a way that sounded real for the first time. It wasn't sadness. It was loss of control. My father didn't cry. He just stared at the floor like he was looking for a loophole. There wasn't one. Within a month, Sterling Trust Company completed the first formal distribution under trust terms. The house remained protected under trust title. Remaining assets were administered with receipts, confirmations, and a paper trail my family could never rewrite. And my brother, his wealth hadn't protected him from a forfeiture clause he'd ignored because he assumed courts exist to reward confidence. They don't. Courts reward records. The night the final confirmation email arrived, I sat at my kitchen table and opened the same folder my grandfather had prepared years before. Not to relive the pain, but to remember the lesson. When people try to erase you with a story, you don't fight story with story. You fight story with evidence. 3 weeks after the hearing, the court entered the trustee's declaration. Sterling locked the trust completely. No changes without in-person verification. My brother's penalty was confirmed under the no contest clause. My parents' settlement request was denied, and the sanctions order required them to reimburse court costs related to the false claim. Within 30 days, the trust administrator executed the first distribution exactly as written, and the trust property remained protected outside probate. No more petitions, no more emergencies, just a finalized record. And that was that.